In this playlist's first video, we open this topic by mentioning Dominion, Representative Devin Nunes, and former President Donald Trump. Each of these plaintiffs shares one thing in common. They are public persons, officials, or involved in matters of public concern. Clearly, defamation law does not just apply to those statements made regarding private persons about private matters. In fact, the most well-known defamation cases pertain to persons in the public sphere. So what makes a person a public figure plaintiff? What are the various types of public figure plaintiff? How does that status affect the case the plaintiff must make? What additional elements must the plaintiff prove? Well, keep watching. This video answers those questions and more. Welcome to Roman Matter. This video will explore defamation law from the point of view of a public figure plaintiff. This video is for educational purposes only. It is not legal advice. And with that, let's get to it. This lesson's purpose is to give a basic overview of U.S. defamation law as applied to public figure plaintiffs. We'll proceed as follows. We start with a lesson introduction covering defamation's purpose and a bit of history. We then explore the various types of public figure plaintiffs. We then spend time on the various configurations in which a defamation case can occur and the legal consequences of each. Next, we explore the landmark defamation case, New York Times Company v. Sullivan, and the elements of fault and falsity in depth, before concluding the lesson. So let's begin. As we saw in the video on defamation from a private plaintiff's point of view, defamation law exists to protect one's reputation. Historically, however, there was no distinction between private and public figure plaintiffs. The courts applied the law to either without distinction. That changed in 1964 with the Supreme Court's ruling in New York Times Company v. Sullivan. We'll discuss that case in detail later in the video, but for now, what you should take from it is this. New York Times constitutionalized American defamation law, created a distinction between private and public figure plaintiffs, and introduced the concept of actual malice. In defamation cases since New York Times, a dichotomy has existed between the kinds of plaintiffs bringing defamation lawsuits. On the one hand, there are private individuals, while on the other hand, there are individuals who are public officials, public figures, and limited-purpose public figures. We need to define those categories because it affects the legal argument each plaintiff must make to win their case. Black's Law defines an officer as a person who holds an office of trust, authority, or command. In public affairs, the term refers especially to a person holding public office under a national, state, or local government, and authorized by that government to exercise some specific function. Case law defines this category in the following way. The public official designation applies, at the very least, to those among the hierarchy of government employees who have, or appear to the public to have, substantial responsibility for or control over the conduct of governmental affairs. Think of President Joe Biden, Missouri Senator Josh Hawley, or the various directors of federal agencies. Those examples of a president, a senator, or someone like FBI Director Christopher A. Wray are obvious public officials. We can think of those persons as sitting at the top of a pyramid. That said, there is no hard and fast rule where those near the bottom of their respective chains of commands or hierarchies cease to be public officials. Those boundaries, think of it as the elevation on the pyramid where public officials are no longer considered public officials, are ultimately made on a case-by-case basis. Nor should you think that public officials are limited to federal offices. The appellation applies to state and local public office holders and their subordinates, fitting the Rosenblatt definition. Now let's take a look at how a public figure is defined. Black's Law defines a public figure as a person who has achieved fame or notoriety or who has voluntarily become involved in a public controversy. Supreme Court case law is more verbose but mirrors this definition. In Gertz, the public described a public figure as an individual who has achieved such pervasive fame or notoriety that he became a public figure for all purposes and in all contexts. Think of Kim Kardashian, Elon Musk, or Joe Rogan. By any measure, these individuals have sufficiently pervasive fame or notoriety to qualify as public figures for all purposes and in all contexts. It's also worth noting that for all intents and purposes, there is no true legal distinction between public officials and public figures, as Chief Justice Warren stated in his concurrence to the court's 1967 decision in Curtis Publishing Company v. Butts. The distinctions between governmental and private sectors are blurred. This blending of positions and power has also occurred in the case of individuals, so that many who do not hold public office at the moment are nevertheless intimately involved in the resolution of important public questions or, by reason of their fame, shape events in areas of concern to society at large. Although this statement originated in a concurrence to a binding opinion, it has since become the controlling rule. Nonetheless, the distinction between public officials and public figures is one every law student must understand. Now, there is also a plaintiff category that splits the baby. Let's take a look at the limited purpose public figure. The legal dictionary defines a limited purpose public figure as a person who, having become involved in a particular public issue, has achieved fame or notoriety only in relation to that particular issue. Turning to Gertz once again, regarding limited purpose public figures, the court stated that often an individual voluntarily injects himself or is drawn into a particular public controversy, thereby becoming a public figure for a limited range of issues. In either case, such persons assume special prominence in the resolution of public questions. Examples of this type are less well known. However, we will discuss two a little later in the video. There's a spectrum upon which defamation plaintiffs rest regarding their public/private figure status, how they are related to the matter of public interest, and the alleged defamatory statement itself. Where the plaintiff lands on that spectrum will affect the legal argument he must make to successfully prove his case. Of course, the plaintiff must prove these elements by clear and convincing evidence. We use this graphic to illustrate that spectrum. Let's proceed left to right. On the far left side, we have purely public matters. In these cases, a public figure plaintiff is suing over a defamatory statement concerning a matter of public interest. In such instances, the plaintiff must prove the defendant acted with actual malice. We'll discuss this in detail later in the video. For now, let it be the left limit of the spectrum. Left of center, we have cases where a limited purpose public figure is suing a defendant over a defamatory statement concerning a matter of public interest. For plaintiffs such as these, the actual malice standard applicable to public officials and public figures only applies to that limited range of issues responsible for making the plaintiff a limited purpose public figure. What this means is that actual malice will apply to a defamatory statement related to the matter qualifying the plaintiff as a limited purpose public figure. A defamatory statement unrelated to that matter is subject only to the ordinary elements of private defamation. For example, if a plaintiff is a limited purpose public figure because he is an expert on respiratory disease, and he is suing over a defamatory statement concerning his work in that field, then he must prove the defendant acted with actual malice. If the defendant had publicly libeled the expert's marriage, then the plaintiff need only prove a prima facie case for defamation. In the former instance, the defamation concerned the matter qualifying the plaintiff as a limited purpose public figure, while in the latter, the defamation concerned a private matter unrelated to that which placed him in the public eye. Generally, there are two ways in which plaintiffs become limited purpose public figures. One, they have voluntarily entered the public sphere regarding a particular issue. Or two, they have gained prominence in a particular but limited field and have not achieved widespread or pervasive public fame. Consider the 2017 case of McKee v. Cosby. This matter involved former Detroit radio DJ Catherine McKee and comedian Bill Cosby. In 2014, McKee publicly accused Cosby of committing sexual assault against her in 1974. The resulting defamation case made its way through the courts. On the question of whether McKee was a limited-purpose public figure or a private figure, the U.S. First Circuit Court of Appeals reasoned that because McKee contacted a journalist and sought to sway public opinion regarding her contention that Cosby was a sexual predator, she had sought the public sphere and its attention. It is because of this the court considered her a limited-purpose public figure. This contrasts with the plaintiff in Woolston v. Reader's Digest Association. In that case, the plaintiff was a nephew of convicted Soviet spies. The defendant publicized Woolston's name in a book published by him titled KGB. The book accused the plaintiff of being a Soviet spy, like his relatives. The U.S. Supreme Court held, on the issue of whether he was a limited-purpose public figure, that Woolston was in fact a private figure. He had not sought the public spotlight, and using the courts to fight an alleged defamation particular to him did not qualify as seeking public attention. These two cases illustrate the salient aspect of the limited-purpose public figure. The plaintiff must either have sought out the public sphere regarding a particular issue, or they must have gained prominence in a particular but limited field without achieving pervasive fame. As an interesting aside, in 2019, the U.S. Supreme Court declined to review McKee v. Cosby. Nonetheless, Justice Clarence Thomas used the occasion to question the court's wisdom in New York Times Company v. Sullivan and its resulting progeny, signaling that at least part of the court is willing to significantly revise U.S. defamation law. I've linked the concurrence in the description below. Right of center, we have cases where a private figure plaintiff is suing over a defamatory statement concerning a matter of public interest. In these instances, the plaintiff need not prove fault, but must prove falsity. In essence, actual malice does not apply to these instances. The case representing this position is Gertz v. Robert Welch Incorporated. Elmer Gertz, a Chicago attorney of some note, represented a client defamed by a conspiracy-minded publication owned by the defendant. During Gertz's representation of his client, the defendant published stories claiming Gertz was a communist and a member of a national conspiracy to undermine the police. Gertz sued the publication for defamation. Welch argued that Gertz was a public figure and that the matter at issue was of public interest. The lower courts agreed. Gertz appealed the decision and the Supreme Court granted certiorari. The court did not extend the additional elements of fault and falsity. In other words, it did not believe that actual malice applied in this case. Gertz had not voluntarily thrust himself into the spotlight. He merely represented a client involved in a matter of public interest. Because of this, he was still a private person, but nonetheless he was working on a matter of public concern. The court held that in cases like this, so long as the states do not impose liability without fault, they may define for themselves the appropriate standard of liability for a publisher or broadcaster of defamatory falsehood injurious to a private individual. In other words, so long as the states did not apply strict liability to defamation cases involving private figure plaintiffs in matters of public interest, they were free to determine the appropriate standard of liability affecting such cases. Lastly, on the far right of the spectrum, we have cases where a private figure plaintiff sues over a defamatory statement of purely private concern. Think of a woman suing a former business partner whom she alleges has defamed her business acumen. These cases do not have any additional elements to prove beyond the prima facie case. For more on this, look at the video on private figure defamation. For now, let's focus on purely public matters. Let's turn to the landmark case that altered U.S. defamation law. The United States Supreme Court constitutionalized defamation law in its famous 1964 case titled New York Times Company v. Sullivan. In that case, L.B. Sullivan, a Montgomery, Alabama police commissioner, sued the New York Times and 4 black clergymen for defamation. The paper had published an advertisement which described, in part, police abuse directed toward civil rights protesters. While the ad did not mention Sullivan by name, he nonetheless believed the public would impute those abuses to him. Alabama state courts, including the Supreme Court of Alabama, found in his favor. The defendants ultimately appealed the case to the United States Supreme Court, and the rest is history. We will use this case and its progeny to explore the two elements of fault and falsity. So let's begin with fault. As we know, under the common law, a court presumes the falsity of a defamatory statement. However, in New York Times v. Sullivan, the court challenged the propriety of this common law doctrine's application to the case due to the plaintiff's status as a public official. The reason being that, in America, First Amendment protections were meant, in part, to facilitate the public's discussion of public matters, and that included the discussion of public officials' conduct in their public duties. Permitting the common law presumption in this instance would chill public discussion and run afoul of both the First and 14th Amendment to the federal Constitution. The court reviewed the Alabama Supreme Court's decision and determined that because Commissioner Sullivan was a public official, the common law's presumption of defamation was inappropriate. Instead, the court ruled that public officials could not recover damages for a defamatory falsehood relating to his official conduct unless he could prove the defamation was made with actual malice. This was a departure from approximately 160 years of U.S. defamation law. So what is actual malice? Well, the court defined actual malice as a defamatory statement made by a defendant with knowledge that it was false or with reckless disregard of whether it was false or not. The test for actual malice is disjunctive and can be satisfied in two ways. The plaintiff must prove by clear and convincing evidence either 1. The defendant made the defamatory statement knowing it was false, or 2. The defendant made the defamatory statement recklessly. After reviewing the applicable law, both state and federal, the court held that the Constitution delimits a state's power to award damages for libel and action brought by public officials against critics of their official conduct. The court dismissed outright the case made against the 4 black clergymen. There was simply no evidence they either knew of the ad's inaccuracies or were reckless in its publication. But how did the court apply this new constitutional doctrine to the facts in the case regarding the New York Times itself? Let's take a look. Factually, the heart of the case turned on an advertisement published by civil rights activists in the Times that was alleged to defame the police commissioner. As it turned out, the ad contained several inaccuracies of the events it related to the public. However, the court found that the Times did not publish the ad with knowledge that portions of its retelling of events were inaccurate or false. Paragraph 3 of the ad stated, "In Montgomery, Alabama, after students sang 'My Country 'Tis of Thee' on the state capitol steps, their leaders were expelled from school and truckloads of police armed with shotguns and tear gas ringed the Alabama State College campus. When the entire student body protested to state authorities by refusing to re-register, their dining hall was padlocked in an attempt to starve them into submission. In reality, the students sang the national anthem, not 'My Country 'Tis of Thee.' 9 students were expelled for protesting at a nearby courthouse, not for leading a protest on the state capitol steps, and something less than the entire student body had protested the students' expulsion. Additionally, the police had not entirely ringed the campus." Paragraph 6 stated that, "Again and again, the Southern violators have answered Dr. King's peaceful protests with intimidation and violence. They have bombed his home, almost killing his wife and child. They have assaulted his person. They have arrested him 7 times for speeding, loitering, and similar offenses, and now they have charged him with perjury, a felony under which they could imprison him for 10 years. Here, too, there were factual inaccuracies. Dr. King had not been arrested 7 times, but 4, although the numbers seemed to depend on who was retelling the events, Dr. King or the police. Sullivan had also contended that any reader would conflate Southern violators and they with the police, because only police can arrest individuals. The plaintiff argued that because the Times had access to news stories contradicting the details in the ad's retelling of events, this fact evidenced either a deliberate intent to report the events falsely or a reckless disregard as to their veracity. Previously, the Alabama court held that the ad's inaccuracies showed the Times cavalierly ignored the falsity of the ad and its maliciousness was inferable from the ad's publication itself. In contrast, the Supreme Court stated that even if the ad was not substantially correct, although the commissioner's own proofs tended to show that it was, the Times' opinion regarding the truthfulness of the ad was a reasonable one, and there was no evidence to impeach the Times' good faith in holding that opinion. Moreover, mere possession of more accurate news stories did not evidence falsity. That the Times was in possession of news stories contradicting the ad's retelling of events did not, in the court's opinion, establish that the Times knew the ad was false, since the state of mind required for actual malice would have to be brought home to the persons in the Times organization having responsibility for the publication of the ad. What we can take from all this is that the defendant must have subjectively thought or entertained real doubts as to the veracity of the alleged defamatory statement. There was simply no evidence the Times felt the information it published was false. The court found that the Times had, at most, acted negligently in its publication of the ad's inaccuracies, but not recklessly. The court stated that the evidence against the Times supports a finding of negligence in failing to discover the misstatements and is constitutionally insufficient to show the recklessness that is required for a finding of actual malice. At the time of the publication, the Times had relied upon the good reputation of Mr. Asa Philip Randolph and other prominent civil rights activists to provide accurate accounts of the events publicized. This was not, in the court's opinion, reckless. It was, at most, negligent on their behalf, but nonetheless insufficient to show actual malice. Again, we can take from this the idea that the defendant must have acted recklessly according to their own standard. The reasonable person standard applicable in other areas of tort law does not apply here. The Times acted much as it did in other instances. It trusted the veracity of a well-known activist before publishing information. This may have been negligent. Perhaps the Times should double-check all information before publication, but it was not reckless. This requirement is rather straightforward, and we will not spend too much time on it. It should suffice to say that unlike a private figure plaintiff, a public figure plaintiff of any stripe to a defamation suit must prove by clear and convincing evidence the falsity of the defendant's allegedly defamatory statement. In other words, a public figure plaintiff must be able to show that the defamatory statement was false in order to prevail against the defendant in civil court. For more on this aspect of defamation law, see Philadelphia Newspapers v. Hepps. There are links to this in the description below. Okay, to conclude, let's sum up the necessary elements making up a prima facie case for defamation as a public figure plaintiff. 1. The plaintiff must show that the defendant engaged in defamatory language. 2. The defendant's defamatory language was of or concerning the plaintiff. 3. The defendant engaged in a publication of the defamatory language to a third person. 4. The plaintiff's reputation was damaged. 5. The plaintiff must prove the defendant's fault. And 6. The plaintiff must prove the falsity of the defendant's defamatory language. This lesson's purpose was to give a basic overview of U.S. defamation law by examining it from the public figure plaintiff's perspective. We began with a lesson introduction, covering defamation's purpose and a little bit of history. We then explored the various types of public figure plaintiffs. We looked at the various configurations a defamation case can take and the legal consequences of each. We then took a look at the landmark case of New York Times v. Sullivan before looking at fault and falsity in depth. That's it for this lesson. If you found it helpful, give the video a like and subscribe to the channel. Leave some comments below and check back often for more content. As always, thank you for visiting Roman Manor and have a lovely day.